How about that? Hey, everybody. Welcome to American Courts Live. It's a Linus special. Hey, Vince. Thank you for coming in. Got a whole pile of people. Hey, Julie. Haven't seen you in a little while, Julie. Thank you so much for making it out here. Yes, Steve, get with Lethal Friction should be in here in just a minute, and she'll be passing out snacks. We got Linus, Sally Port, Jay. We were just over at Jen Hardy's live. She was talking with a narcissist doctor. Uh-oh. Hey, Drunk Beaver. I'm glad I got to help you test out your headphones there. Got a bunch of people over here. I got Lethal Fiction. Should be Lethal Friction should be here in a second, so we'll be ready to go. Last night or yesterday was Linus's birthday. It's 2:00 in the morning there, so and I told her now she's just old and broke. It's not birthday girl anymore. But thank you everybody for coming in. I'm just trying to give them a second to get over here. Is anyone following the Tellus trial? Julie, I actually have that recording right now. I was recording it so I could watch it later. But yeah, I'm watching it. I've been talking with Linus, thinking about it on the weekends, just rather than trying to find local courts, trying to catch up on some of that stuff. Hey, LD. But Julie, get up with me later because I'd like to talk with you some about the weekend plans. I was talking about just trying to keep up with some of these national stories that we tend to not pay a lot of attention to, or we pay too much attention to. So I'm gonna go ahead and jump into a Magistrate Norbeck one. It's a neat little traffic one, and then we'll go on to the next. It's only about 8 minutes.
Calling into court, sir. What's your name?
Goran Zafirovsky.
All right. This is a citation. It was issued on July 1st of this year on I-196 there at Saugatuck Township. It's a citation for careless driving. Mr. Zafirovsky, you're here on this citation to do one of three things. First is you could admit responsibility to this citation, or two, you could admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What are you looking to do?
Option number 3.
All right. Then the first thing I'm going to do is have you both sworn in. So if you could go ahead and raise your right hands. Other right hand, sir. You swear or affirm any testimony that you would give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Mr. Zafirovsky, it makes a lot more sense for me to start with the deputy. The deputy has the burden to establish to me why you were issued the citation in the first place. But after that, you'll have an opportunity to either ask questions or testify in your own behalf, all right?
Okay.
With that, deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation?
Yes, sir. So on the date in question, July 1st at about approximately 10:30 p.m., I was driving southbound on I-196 at about the 41 mile marker in Saugatuck Township. In front of me was a semi. I observed the semi crossing the center line abruptly and then shooting back over to the shoulder. I then followed the vehicle from the 41 mile marker to the 37 mile marker. And when doing so, the driver was observed crossing the center line several times, crossing the fog line, driving on the rumble strips, and driving over the line onto the rumble strips for an extended period of time. Therefore, I stopped the vehicle at about the 36 mile marker. And when I stopped the driver, at first he advised that he may have been looking around the cab for something. And then when I issued the citation, well, that's why he got the ticket for careless. But when I issued the citation, he then changed his story and advised he was attempting to miss potholes.
Okay.
But he was given a careless citation because he advised he was looking around the cab, which was causing him to swerve.
And then, sir, what is it you'd like to tell me?
Is it my turn to talk?
Yes.
I misunderstood him because he said that he was following me for some time. I didn't know for how long he was following me. I did cross into the left lane, and there was no one next to me in the moment when I did that at the 40th mile marker. But when he asked me that, I thought that he probably saw me earlier, and I did mention to him that earlier at the mile marker 47 to 46, there are 6 potholes that are pretty deep that I avoided at that location. And when he told me that he stopped me, he said that he's been following me for a long time, and I didn't know how long he's been following me and about which swirling he was talking about. So I did avoid something at the mile marker 40, and after that, he said that he was driving behind me, so probably he saw that there was a straight truck behind me, that straight truck passed me somewhere around mile marker 39. He started passing me, and then he passed me by the mile marker 38. And the police officer was driving in a left lane. I could see him on a mirror. So if that straight truck was thinking that I'm driving carelessly, that means unsafely, then he wouldn't pass me. So I do believe that I was driving appropriate and that I wasn't being careless.
Mr. Zaborowski, let me tell you certain things. Well, first of all, if a person behind you thought you were driving unsafely, that might be exactly why they passed you, because they want to get away from you because you're swerving. Secondly, you're not avoiding potholes in the area of exit 41. They just redid those roads for miles and miles just last year. There are no potholes. And thirdly, even in a passenger vehicle, you really shouldn't be driving this way, where in observation of just a couple of miles, an officer can see you cross the center line, cross the fog line, hit the rumble strip several times, let alone in a semi. That's why it's even worse. You're this big, massive thing. You can't make corrections and take evasive action the same way a passenger vehicle can. I am going to do you a little bit of a favor. In other words, on this particular citation, careless driving is an ugly citation. It's $225 fine. It's 3 points. It's usually because that cumulatively you have made more than one different type of moving violation. Essentially, what you're doing is the same moving violation, but several times. What I'm going to do is find you responsible, but I'm going to find you responsible just on improper lane use. In other words, not staying in your lane, crossing center line, hitting that fog line. The difference is the fine's $110, and you're really only going to get 2 points from Secretary of State instead of 3. So I think you understand why, in fact, that is a better ticket. But because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing in front of the district court judges with the prosecutor's office. But if you go to formal hearing, you will be in formal hearing on your original careless driving ticket. You would not get the break that I'm giving you of finding you responsible on a lesser ticket. I want you to understand that. But if you wish to pursue this to formal hearing, you must do 2 things. First is you must ask for that within 7 days of today's date. You can only pursue that for 7 more days. And secondly, you would have to come in and post a cash bond in the same amount as the fine to guarantee your appearance. Do you understand your rights on appeal?
Yes, I do.
All right. So if you accept my finding on that lesser ticket, then you would just make arrangements to pay the $110. Or if you wanted to contest this further to formal hearing, you'd take the 2 other steps. All right.
Okay.
And so with that, I'm going to go ahead and release parties. We're all set here. That was your only one, right? Thank you.
Yes, sir. Thank you.
That's one of the reasons I like Magistrate Norbeck. He gets him in and gets him out, and he doesn't give him a lot of arguing time on there. So I got my CDL when I was 18 years old. In Florida, if you're going to drive in the state, you can get it at 18. So I got it when I was 18 years old. It was only offered in English, and it was very difficult. I'm in the transportation industry now. I deal with truck drivers on a daily basis. And I know right now in Florida, they're offering the CDL test in over 50 different languages. I deal with drivers who cannot even use their phone translator to communicate. They have to call someone so that they can communicate. And so that's a challenge all in its own. And then you've got this guy on the road driving around, driving goofy. I think his English was just fine, but then he's arguing. Haha, thank you. Thanks a lot, Lethal. But then you've got this guy here who speaks good English, but he's going to tell the judge that he was just confused, didn't understand what the officer was saying. I've gotten that plenty of times from truck drivers who don't want to follow the rules and want to do whatever, because most people are going to give you the benefit of the doubt. Most people are going to be good people, and they understand if there's a language barrier, they don't want to become an extra challenge for you. In the end, they want to get through their day, let you get through your day, and hopefully no one gets sued. Vince, work for 3PL? Absolutely. I'm a contractor for Amazon and several other companies like that, and so I'm right there with you. Metal Rules, how are you tonight? Oh no, roll on. We got to do something about that. How about this? We're gonna go over to Collier in Florida. He's down in Port St. Joe, Florida. So let's go down there and let's let him deal with a sovereign citizen.
Morning, Your Honor.
Good morning, sir.
Mr. Bacchus is here for a violation of probation preliminary hearing. He has not yet requested the appointment of counsel. He did at the last time he was here, but not this time. So I'm not sure where Mr. Bacchus stands.
I'm pro se. I just rather.
All right, raise your right hand for me, Mr. Bacchus.
Yes.
Would you tell me your name, sir?
Cameron Christopher Bacchus.
Mr. Bacchus, you're here for a VOP, violation of probation arraignment. It's a critical stage of the proceedings, so I have to advise you that you do have the right to an attorney. If you can afford an attorney, we can appoint the law office of Henry Mark Sims to represent you. He's our elected public defender here in the 14th Circuit. I believe you're familiar with Mr. Hill, who's his chief assistant here in Gulf County. I'll appoint Mr. Hill's office to represent you. It looks like you had Mr. Wilson previously, and if Mr. Hill has a conflict, I'll appoint Mr. Wilson's office to represent you. You also have the constitutional right to represent yourself, and if you want to do that, I'll ask you a few questions. You also have the right to hire a private attorney. So how do you want to proceed, Mr. Bacchus?
With a further inquiry, sir?
Okay. So tell me your age.
Okay, my age is 30, just turned 40, actually.
Okay. Congratulations on your recent birthday. What's your highest level of education?
GED.
Do you have any legal training?
I have been studying law. No, I do not have a legal degree, but I do understand written English language.
Do you understand the written English language? You're proficient in English. You can read and write it well?
Yes, Your Honor.
You understand that if you want to represent yourself, I'll hold you to the same standard as I would a member of the Florida Bar or licensed attorney?
Yes, Your Honor.
That Ms. Smith, who is a licensed attorney, has experience, and I can't intervene on your behalf. That you may be at a disadvantage by representing yourself.
I understand.
Are you familiar with the rules of evidence in the state of Florida?
Yes, Your Honor.
How familiar are you with the rules of evidence?
I've never actually been in trial, so I've never had to submit any evidence. Today, I'm not wishing to contest the.
Before we get there, let me finish asking you a few questions. So you say you're not too familiar with the rules of evidence?
No, I'm not.
Do you understand? Let me see, this is a third degree felony. So what's the maximum imprisonment that you may face? And what's you're on a violation of probation. You understand what that means?
That I.
That- You've alleged to have violated the terms and conditions of your probation? Are you on the influence of any alcohol, drugs, and medication?
No, Your Honor.
Have you been prescribed any medication you have not taken?
No, Your Honor.
What's your familiarity with the criminal justice system?
Brief.
What do you mean by brief?
I represented myself last year, or not, in 2022.
In this case?
No.
In another
Actually,
case?
I attempted to, but I went ahead with Russell Wilson because I had conflict attorney.
Okay, what caused you to change your mind and go with Mr. Wilson?
Time.
Okay, Ms. Smith, you have any additional questions? All right, Mr. Pockets, I'm going to find that you're competent to represent yourself. You're here for your violation of probation arraignment. How do you plead?
To violation, I plead guilty.
All right, you admit that you violated your probation?
Yes.
Anyone threaten or coerce you in any way to get that you violate, to have you admit that you violated your probation?
No.
Do you have a dispositional understanding about what the sentence may be?
Yes.
What's that?
Up to 5 years in DOC.
Anyone promise you what the court may impose?
No, Your Honor.
Okay. You want to be, could you tell me how you violated your probation?
I was arrested by Bradford County Sheriff's Office.
What happened with that charge?
It is my understanding that the state never filed charges. I was charged with a DUI and driver while license suspended. I was released on ROR due to the state not filing charges after 72 days.
Were you also arrested for driving while license suspended, canceled, or revoked?
That was one of the charges, but I don't believe that that was a valid charge.
So you're telling me that you did not engage in any criminal conduct? Is that what you're telling me?
I was driving.
Did you have a valid license at the time you were driving?
I understand that I did. Yes, Your Honor.
And you say that you were not driving under the influence to the state your normal faculties were impaired?
No.
So how are you admitting that you violated your probation, but then you tell me you did not engage in any criminal conduct? It can't be both.
Negative contact with police officers. I did get arrested.
Simply by being arrested doesn't mean you engaged in criminal conduct.
That's the way I thought a violation worked. If I got arrested by the police officers for no matter what, even if I wasn't charged with a new charge, I still had negative contact with the police.
No. The way it works is you don't have to be convicted. So if you would have went to trial and been found not guilty, you could still be found in violation of your probation if I find that you, by preponderance of the evidence, engaged in criminal conduct, not that you had negative interaction with law enforcement. That doesn't violate your probation by having quote unquote negative interaction with law enforcement. So you either engaged in criminal conduct as alleged on your affidavit of violation of probation and you admit to that, or you did not violate conditions 5 of your probation, and we can proceed to an evidentiary hearing. So how do you want to proceed?
No contest.
This isn't, Mr. Baucus, this is a violation of probation. You either admit that you violated your probation or you deny you violated your probation. We'll proceed to an evidentiary hearing.
I violated my probation, Your Honor.
So you admit that you engaged in criminal conduct
Yes.
on, looks like December 11, 2023 in Bradford County, Florida.
Yes, Your Honor.
Do you admit that you were driving or operating a motor vehicle and you did not have a valid driver's license?
Yes, Your Honor.
Okay. Is there, excuse me?
I said I'm just gonna go with it because I'm.
No, I don't want you to just go with it. If you didn't violate your probation, you can enter a denial, and I'll set this for an evidentiary hearing, and the state will come in and have to prove by the greater weight of the evidence that you're on probation, you're notified of the conditions, and you violated the conditions of your probation, and your violation was willful and material. Or you can admit that you violated, which you're telling me you did, but you can't equivocate, jumping back and forth across the fence saying, well, I did, well, I didn't, well, I'm just going to do it. I need to know.
Your Honor, I'm gonna plead with mercy on the court and I'm gonna admit to it, yes.
You understand you're waiving your right to that evidentiary hearing?
Yes.
All right, anything, I'm going to accept your admission as known, intelligent, and voluntarily made. Is there anything you want me to consider before I impose sentence?
Me?
Yes, sir.
Yes, when I did leave this county and I made it back to Bradford County, I did the best that I could. I remember I told you I was homeless. I went, I found a place to live, I got a job, I did my drug alcohol evaluation, I was attending my classes as were, and I was paying my restitution. I was doing everything I was supposed to be doing, but I had a lapse in judgment, and what happened, and I'm not gonna deny it. And I'm going to plead mercy with the court to perhaps reinstate my probation with no modifications.
You said you were undergoing a mental health treatment. Do you
It's
have any,
required by your own.
do you have a history of mental health issues, sir?
Yes.
What is that?
I suffer from traumatic brain injury
And when did that incident take place?
when I was 3 years old.
How does that affect you?
Judgments and some decision-making skills, as well as my sense of smell and some other, because I get hit my temporal lobe. So,
You say judgment and decision-making skills. Could you elaborate?
throughout my life, I've been in and out of jail. I did not believe that some of the things that I did was actually wrong, but again, I did end up in jail. I pled guilty to it. You know, I don't, after being 40 years old, being 40 years, you know, I'm learning how to deal with it a lot better than I did when I was in my 20s. You know, at least now I understand it more than I did.
Does your traumatic brain injury affect your ability to understand your decision to represent yourself?
Yeah, it does.
It does?
It does.
All right, what I'm going to do, I'm going to, on your behalf, let you withdraw your admission that you violated your probation based on your testimony that you suffer from a traumatic brain injury that affects your judgment and decision-making skills, and that it does affect your ability to understand your right to counsel and represent yourself. I'm not going to let you represent yourself in this case. I'm going to appoint Mr. Hill to represent you.
Thank you.
Right now, there's a plea offer for DOC time on the table. I'll need to discuss this.
Hey, Chris, thanks for coming out. Omnicast. Hey, Vince and Bodie, how are y'all doing tonight? Did y'all just see that this guy talked himself into jail and then talked himself right back out of jail by letting the judge know he's got mental issues, and therefore the judge chose to back him out of pleading for himself. So I'm going to do that. If I ever get caught up in something, I'm going to try to talk my way out of it. And if I can't talk my way out of it, backtrack. This guy did a good job with that. I was impressed. I did find the noise though. If you watched his hands, it's every time his handcuffs hit that dang counter he's at, the desk that he's at, it was tripping off that microphone. So if any of y'all got some friends out there, y'all say something to them. You're right, Chris. You found all the cool kids. We're hanging out over here. There's a big difference between seeking help and getting helped. Absolutely. Well, we got to watch that with Judge Fleischer, and you get to see it quite a bit over there. Sometimes these judges have to talk people into not being the knuckleheads that they are, and sometimes they have to force them into it. It's good to see when they can talk them into something, but sometimes you got to beat it into them or let them go sit for 10 years and figure it out. Steve Bennett got a brain injury, shaking my head. I can outdo this guy. Absolutely. We're going to jump back into it and see where it goes on there.
Situation further with Mr. Bacchus before he enters a plea, and I would ask that we bring this back. He's incarcerated. We can bring him back on the May date, Judge. I'll get out to the jail and talk to him, and if he wishes to go forward with a plea or hearing, we can go that route.
Okay, let's bring this back for a VOP pretrial May 9th. If we don't have it resolved, I'll put you on the evidentiary hearing. That will be June 28th, okay? So we're going to come back in a few weeks, May 9th, and see where we are.
Thank you. How you doing, Sergeant Strickland? Go as well as I wanted.
Mr. Breeze boy. Go on to Mr. Mumford.
Jeremy Mutz on behalf of Michael Breespa, and I work for Mr. Mumford.
Yes, sir.
At the Ticket Clinic. So here on his behalf, and I just kind of maybe need to explain a little bit on the 2023 case. For the record, 23-70 CF. It's starting to get a little bit of age on this case, Your Honor. However, part of that is because my client has a new charge, 24-36 CF. The state, I guess in the past week, has made us a global offer on both. However, we technically don't represent Mr. Griesbach on the 24 case. I thought we might be able to resolve both nonetheless this morning, but we're still too far apart on the offer. I would ask for a continuance on the 23 case for 30 days. And I think that'll give us time to talk to Mr. Griesbach more about what he's facing. And if he wants to hire us on the new case, we can dive into that one as well. I am at this time going to present the state with thumb drive because there is an additional video on the 23 case that we need as well. And I just feel like I need to do some more due diligence, both on the 23 case and certainly on the 24 case before we're able to resolve it. I'm still hopeful we might be able to negotiate something, but we do need that additional time.
Mr. Breezeboy, how do you intend to proceed on a 2024 CF 36 case? Want to represent yourself? Want to seek the service of the public defender's office, or do you intend to hire private counsel?
Like right now, I'm on a revoked bond. If I could get out, I'd hire counsel.
Do you have the means to hire counsel? Okay. So you don't qualify for the public defender's office based on your own admission. You're not going to get out. So you can represent yourself or you can hire private counsel.
Private counsel, not near.
Okay.
I have no means of doing that.
All right. So how, excuse me?
I can't do it inside the jail.
You said you have the means. I mean, you can call a family member. I'm not letting you out
I
of,
don't have any family here, so I
well,
don't have any family.
well, you have the means, so you're not indigent. However, you intend to hire private counsel, I'll leave that up to you, but I'm not letting you out of jail.
And I would just ask if your honor is comfortable with it, if we could continue both for
Okay.
30 days, and I'll talk to him about both. If he hires us, I mean, I'm happy to try to help him with both.
Yeah, our,
I only said that because if I was able to get out, I was gonna work and do it. But I mean, if I can't get out and work, then no, I don't have the means to work.
okay. We'll come back on. You want to come back in May? That would be May 7th, or we can come back in June.
Whatever defense counsel wishes, Your Honor.
Mr. Mutz?
I think the May court date would be good. I'd like to try to see if we can't resolve.
Okay, well, that will be for an arraignment. Have we filed on the 24 case?
We have, Your Honor, there was a recount information.
Okay, file enter a not guilty plea on your behalf, Mr. Breezeboy. We'll come back May 9th at 1:30.
Just double check that date.
Morris?
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23-174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer Henry Mark Sims to represent you in the 24 case.
I go state this to the court.
You raise your right hand and
Yes.
now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that
Oh.
writing right there. Said he's not a citizen and something about a secured.
My name is Alize Morris, a secured party creditor under the UCC 1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States, not a record. So on documentation, there's official records. So stated, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
Just memory
Okay. Tell me what the 14th Amendment says.
that you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This if you commit a crime
Okay. Doesn't say if you commit a crime.
or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What
Right.
book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's
I was
because it's an amendment to the US
It's-
Constitution.
Mhm.
So you don't know what the 14th Amendment reads.
The 14th Amendment reads not off the top. Not off.
Okay.
That's
What else
why I
do you-
written
What else do you want me to consider?
that I'm a secure party credit under the UCC 1.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the
says-
UCC 1 reads, do you?
Not on top.
You're not
I
prepared
wish-
you're not prepared this morning with your sovereign citizen argument? You needed some
I just
additional
want-
time to
Yes,
prepare?
sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
I would ask that, he's got 2 cases. I know one we've got, already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I mean, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
So this judge right here was elected he was put in place by the governor. He'll go for election this next round, and I know in the county that he's in, my in-laws actually live in the next county over. He's very well respected, and he does a great job. He's done a great job so far, and people really respect him. So I love to see him let people fall on their own swords. He gives them the opportunity for it, and they certainly take it. Let's go to Judge Simpson from today. Judge Simpson had a couple of good ones from today. I guess he took off some time last week, but he's back on the road today. So let's see how it goes.
Are you appearing for Dane Jones?
Yes, Your Honor.
Okay, I don't have a substitution.
My apologies, Judge. I was brought into this case by Mr. Jones' parents today. This is the first notice I got of the hearing as well. My appearance will be filed, or substitution will be filed forthwith.
Mr. Jones,
Yes,
you have a camera?
yes. I'm trying to figure out how to turn it on now.
All right. How much time did you want me to adjourn this out for while he figures out his camera?
Are you addressing me, Your Honor?
I don't know.
I would
Who's
ask
going to
this for-
speak on this?
If he,
All right, look, I'm just going to put it out. Probable cause is adjourned to September 12th, 2024. You get your substitution in. Everybody get themselves together. Mr. Jones, figure out how to work your camera. And we'll be good.
Yeah.
Thank you. Bond continued.
thank you, Your
Thank
Honor.
you,
right,
Judge. Thank you for your flexibility.
Yeah.
Thank you.
That's all I have. Clerk calls the case, People versus Kara Gray.
Happy to announce you don't need a Ouija board for us. My pleasure.
You're great.
Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Gray. All right, Ms. Barroso is appearing on behalf of.
Assistant Prosecuting Attorney Mark Grosso, on behalf of the people.
I just kind of skipped it.
I didn't give it.
She's not gonna give her name. I'm not. I'm done. Anyway,
So, Your Honor, we are this close to having worked this matter out. Should we approach?
Can we approach briefly?
apparently, yes.
Now we're ready on Kennedy.
Hold on a second. Let me figure this one out because I don't believe I went here on whenever I was getting this video ready today. So we're gonna call this one a small mix up, but I'll find it quick because I know I downloaded it all. So let me figure this one out. That's why there's. Yep, Julie, if you'll check out that like button, I really appreciate it. We'll get you the video on here. I'm not even sure. Oh, this is the video from yesterday. So we'll do good. So let me grab this and.
Court does call the case, People versus Cedric Blair. No relation.
So on behalf of people.
And good morning, Your Honor. Sydney Russian at behalf of Mr. Blair, who's of course, all right. Restate your name for the record.
Cedric Blair.
Thank you. Your Honor, today is the date and time set for a probable cause conference. At this time, we would like to schedule this matter for a preliminary examination.
And all discovery is complete.
Yes, Your Honor.
People have their witnesses available the 3rd.
We will do our best.
Preliminary examination in person, September 3rd, 2024, 9 a.m. before Judge Perry.
Your Honor, may I briefly address bond?
Okay.
Thank you. Your Honor, Mr. Blair's bond is currently $10,000. He cannot post that. I'm asking Your Honor to consider lowering his bond to a personal bond, but if not a personal bond, at least a 10% provision. Prior to this, Mr. Blair had job interviews at both Applebee's and Five Guys. He believes that those are still going to be available to him. He has no prior felonies. And Your Honor, and for what it's worth, I have been contacted numerous times by the complaining witness in this matter. I have not reached out to them. And I'm constantly being told that these allegations are lies. So I'd like Your Honor to take that into consideration for what it's worth.
Response from the people.
I do want to correct, the defendant does have a prior felony. He has a CCW conviction out of Georgia from 1996, as well as a reckless conduct and a trespass, all out of Georgia. As far as this particular case, the defendant was driving 120 miles on the highway.
Excuse me. Look this way. Thank you. Go ahead.
He was hitting barriers, assaulting the victim. The victim called 911 and was screaming out the window for help. He pulled into a gas station, got out of the car, and pulled the victim out of the car by the hair and started punching her. Officers arrived to see the defendant physically assault the victim and the victim crawling on the ground to get away from the defendant. The defendant then resisted officers before successfully being placed under arrest. At this point, we did request 500,000 cash or surety for bond. He had said 10,000 cash or surety, and getting the time to be appropriate.
Anything else?
Your Honor, just for the information prior to any of the officers' involvements, I guess those are all fabricated from what the complaining witness had put in an email to. So I was just asking Your Honor to take that for what it is.
Motion for bond reduction is denied. Bond will continue. Thank you.
It's to my left.
Other side.
Oh, right. Sorry.
Your name, sir? Thank you.
Well, I'll just start. we've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A
converted
second case on,
on the same, calling from the jail. Allegedly, everything's allegedly.
oh, the
Calling
witness,
from the jail.
right. Okay, he picked up the,
Everything's alleged.
right.
So that caused a second case and, in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you you weren't fighting for him?
Oh, for sure. And a lot more too. Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me. When defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this, you were fighting for them, you were fighting at me a little bit with this thing. And then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, you know, that fight is, it wasn't quite anything you did. It's just in your, it's just in your blood.
Thank you.
It is your heritage.
I was carrying
He
my
doesn't
fighting.
understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forth, but you understand that, Mr. Abs?
I understand everything.
Okay, then let's set.
Right.
Correct. So
Just to the courts.
He has discovery on the first one.
on the first case, but not on the
Yes,
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it
Correct.
all, so I want to make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on with our victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Will the court please explain to my clients certain instances where they can go forward without the victim? Excited under its mental state, it's.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of
that's,
the technicalities would be MCL 768.27C. And as I indicated, that case, people versus only 327, Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all,
And-
it's
and
all
other.
of that kind of thing.
Do I
They
got a
will-
right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could.
I'm
not, I know, but I'm just saying there, that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay,
for
I'll
her.
tell you.
She asked the
We
question.
have told you.
I
I'll
asked
All
tell
right,
you.
I'm done. I'm gonna set it for exam.
I'm gonna go to the jail today, so I will.
So
I'll
what's
tell
that?
you.
Preliminary examination in this matter, because the
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse
Why
me.
so long?
Uh,
That's 3 weeks.
yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar, and I'm gonna defer to professor. There are some
You can ask
parameters,
for
and you
another
are not
speedy action.
being. Oh, that's the new
In-
thing in the jail I'm learning, that I'm being.
And I would anticipate the
Oh.
people's motion, so we'll try to
Speedy
hear
trial
that.
is the new
before the-
buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has,
Judge Sims, can I ask a question?
He gave me the perfect time to break into this one. Everybody, if you hadn't noticed, it's Linus's birthday. She's happy about her birthday. Make sure to tell her thank you. We do appreciate her. We appreciate all that she's done for the channel, and in general, she brings a good energy to things. We do appreciate her. We have a Discord link there at the top. Make sure to stop by the Discord. It makes it really neat to see people's names and faces pop up and have those conversations. Linus, I'm gonna throw something on the screen for you. So happy birthday, Linus. Lethal Fiction had posted this earlier. Said when Will found out Linus wasn't in the chat, so there you go. We had a supporter of the channel, Tiffany, give a very generous donation. Gave a $50 donation to the Buy Me a Coffee thing. Thank you so much, Tiffany. We really appreciate what you did there. Well, here we go. We go back to this nice guy trying to educate his lawyer. This right here tells you how defense lawyers are better people than me, because the first chance he gave me, I would have found a way to get out from being his lawyer, and she keeps putting up with his garbage. So there you go. Thank you, Legal Fiction, for informing Will of the bad news that Linus wasn't in the chat. Thank you so much for that.
What is about what's going on in the jail, speedy, none of this
You
particular
just
about
said
my
speedy.
case.
You just said you had a right to
Like
speedy
this,
trial.
I didn't say, I asked why so long. I didn't say nothing
It's
about
not a
no speedy
violation
trial.
of speedy
I
trial.
asked why so long. I didn't say nothing about no speedy trial. Like, Judge Sims, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
okay,
All this
but Mr. Epps,
speedy
hold on,
trial.
slow down. You have two things now which have,
And I
hold
understand
on. You asked me a question, but you're operating off of a premise that isn't gonna work. So here's the thing, you had the one case come up. We then had the hearing, there were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure, the allegations have been made, there's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. F, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up. Okay, so that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know, they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
When, excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked.
I'm not able to get a hold to you.
I don't.
But we talked.
That.
He's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
You should be able to contact your attorney.
I'm not able to, sir.
Well, I can. Did somebody at the jail make sure that can happen? Ms. Ford, check into that if you.
All right.
I'm done here, folks. Bond continue.
Thank you.
You lose them. You know.
Deborah Jolene, on behalf of Michael Horn. This is a happy story.
Oh, you don't want me getting after him?
No.
No, okay, I'm just asking. I'm just trying to be helpful. Your name, sir? Thank you.
He's asking for a preliminary examination.
All right, and I'll discuss.
He doesn't
What?
belittle me, and he listens, and he calls his probation office, what's it? Tether, I call probation, but Tether agent Josh Bennick, I've spoken with him. He cooperates, wants us to know.
Wow, it's funny how that works out better when you do that. I don't know. And it's interesting when you kind of do that, he's out. The other guy, I don't know. Something.
He is asking though, for one thing, while I remember.
Oh, now he wants me to see.
Yeah.
I knew it. And anyway, go ahead.
But he really, everything I said though was accurate. He would like bond permission. I call it tether to go look for work from 6 a.m.
Okay, hold on. Let me first do this.
No, excuse me, 8 a.m. to 6 p.m. Right.
Hang on. Let me first deal
Sorry.
with setting the exam.
Okay, sorry.
Okay. So would the people have their witnesses available the 3rd?
We'll do our best.
I know I have a major exam about Chester Hill.
What about the 10th?
The 3rd is fine. We'll do our best.
I can't.
So would the 10th work for you?
We'll do our best.
Just a minute.
So
Is it
I'm taking
possible-
that as a yes.
As far as I know.
All right.
Is it possible to put it on the same day as the other case?
To choose.
Is that too much?
Okay, I'll put it there, but you may be before another judge. Because you don't get to choose that either. So, I mean, it's just gonna be, it will likely, okay, look. Let's just do this. Before I give a date, what is your other request with the tether?
Oh, from 8 a.m. to 6 p.m. that he could look for work.
Who is that? Blanche? Is that Blanche? Oh, that was you? It was Blanche? Yeah, it sounded like a Blanche sneeze because she interrupted the court like 8 times the other day. Okay. Do the people have a response on the request to go look for work?
I will say I'm a bit confused why he needs to get Heather to go look for work for that large of a time span, if he had an interview set up or if he had employment already, I would be more inclined. But he's out on a PR with home confinement and we requested 250,000 cash or surety in this case because it is a firearm case. He has a prior CCW from 2023. There's a CCW, PD, and AB, A and B, and L is all up here. It's about the defendant texting threatening messages to his ex-girlfriend, showing up in a car, pulling up alongside her, punching her multiple times. And this is after threats. He then grabs a gun, points it at both the victims before leaving. I'm
Okay, so here's what I'm gonna do.
May I say, just respond before I do by a little bit? Okay, he indicated he was not convicted on any gun case, but more importantly, people do murder and get out and they.
Not here, they don't.
Well,
I don't know where you've
no,
been.
this
But,
my client.
okay, look,
Good job.
here's the thing.
He doesn't
Here's the
have-
thing. I'm gonna give you your exam date. I'm not changing anything regarding bond.
Okay,
Okay, I'm just gonna leave everything where it is currently.
okay.
Okay, so what date did you need, counsel?
Thank you. September 17th.
Preliminary examination in person, September 17th, 2024, 9 a.m. before Judge Valvo.
I'm sorry, Judge who?
Valvo.
Okay. Thank you.
Bond will continue. Thank you.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Lowe, who's approaching to my right. You state your name for the record, Mr. Lowe?
Kyle Anthony Lowe.
Thank you.
Okay.
Your Honor, today is the date and time set for a probable cause conference. I believe there is a form in your file. We are attempting to get this screened by the mental health court. We do need your signature on that for him to be screened.
I signed it.
Oh, thank you so much, Your Honor. So at this time, I believe we would just like to set this out for another PCC date while that process, it goes through the process.
I'm not clear how long they're taking. I mean, I'll set it for the 12th or the 19th, which would.
Can we do the 12th, Your Honor?
All right. Let's see what happens. September 12th, 2024, 9 a.m. Bond continue.
Your Honor, would you allow me to address bond? I did talk with the people prior to this request.
And what they say.
They said that.
Okay,
I'll let them
never
speak.
mind. Go ahead. Go ahead. You did.
Your Honor, Mr. Lowe's bond is currently at $500. He is unable to post it. The reason that he is in custody is he missed his preliminary examination, which we were going to be getting this all in process at that point on July 9th. Prior to that, Mr. Lowe was always on court, always kept in contact. What happened was his phone got broke, so we lost contact. He is obviously back in custody. He has the information that he needs to call to the 15th District Court to immediately set up this intake with the mental health program. I've asked the people, their input, but I'm asking Your Honor to consider lowering his bond to a personal bond, as he will appear at court.
Your Honor, bond $500. They pulled Ms. Rushing, and I'll tell Your Honor, I'll leave it in the court's discretion.
Thank you. So would he be staying at the Delano Center, or?
That's where he would
is
be
that
going.
where that's what you're gonna try to do? And
Yep.
keep in contact there?
Yeah.
Okay,
And I'm gonna try to buy a cell phone too, to stay in contact and stuff, and set up an email address and all that good stuff too.
Yep.
okay, so, let me just does he have your information?
Yes, Your Honor.
That he can, while he's trying to get a cell phone, he at least has that so he can keep in touch with you?
Yes, Your Honor.
Your previous conditions will remain in effect. I'm gonna reset your bond to $5,000 personal recognizance bond. I'm gonna let you go. Okay, young man,
Nothing further, Your Honor. Thank you
I'm
so
gonna
much.
let you go. Make sure you come back, you hear me?
Well,
Because if you don't, then you know what's gonna happen, right?
I don't want to wind up back in here.
Yeah, okay,
Thank you so much, Your
good.
Honor.
Thank you.
Mr. Jones, your name when you approach the podium.
Mr. Jones was walking up there like he didn't know which way to go. He was here before me yesterday. He knows how to get up to the phone. Never mind. What you say?
Your Honor, today is the date and time set for the probable cause conference. I've spoken with the prosecution briefly, as well as.
Hey, everybody, I'm going to go ahead and address a couple of these ones. Let's go back and see this guy. So this Travis Bogan, Steve had asked me about him. I don't know if I sat and waited on him too long. So whenever he came up, it wasn't real exciting for me. I didn't think there was any educational or entertaining value out of it. I'll go back and look at it because if Steve asked about it, it must have something to it that I missed. So I'll go back and look at it. And the same with this Tyler Meddy guy. I was watching Judge Fleischer earlier, and Grumpy had alerted me to this guy. Just acting odd. He was at one point he was picking his nose. Another point he was, I don't know if he's doing gang signs or what at the camera, but and at the end they just passed this case along. So, but neither of them did I see as being anything special. But I'm gonna go back to this Travis Bogan because there may be something to his. I've got it. I just whenever I try to edit the clips, I try to find the most interesting ones. And today, Judge Simpson's behavior was the most interesting. You can just tell he just come back 2 days ago, but it looks like he's ready to take another day off. It's got a mess there in the courtroom. But if y'all get a chance, Jen Hardy did an interview with a doctor for narcissists in the prison system. It was really interesting. It was a lot of learning there. A lot of things I hadn't thought of. A lot of questions she answered on it. So it's worth it to go back and watch that live. She aired it at 7 p.m. She's going to start doing her show at 7 p.m. on Mondays and Thursdays. Make sure to check it out and support her. Every show may not be the one for you, but tonight was definitely a very interesting show. She's doing good. She's also got a video out with Judge Fleischer where she does an interview with him, and she asked some questions of him that I hadn't even thought to ask of him. And so it's an interesting interview. So we're going to jump back in this one. It's got about 5 more minutes, and then it's about that time of day. All right, you take care, Steve. Thank you for coming out. Thank you, Steve.
You hear me?
Well,
Because if you don't, then you know what's gonna happen, right?
I don't want to wind up back in here.
Yeah, okay.
Thank you so much, Your
Good.
Honor.
Thank you.
Mr. Jones, your name when you approach the podium.
Mr. Jones was walking up there like he didn't know which way to go. He was here before me yesterday. He knows how to get up to the phone. Never mind. What you say?
Your Honor, today is the date and time set for the probable cause conference. I've spoken with the prosecution briefly, as well as my client. It's a matter we think can be resolved, but we're going to need a week to be able to get that resolution in place. My client would respectfully request that we address the issue of bond.
I know that he would. If I adjourn it out a week, has anybody talked to you about your housing?
I swear to God, I'm gonna get with Ashley and them.
Pardon?
I saw that I'm released. I'm going to go get in touch with Ashley from Alabama. I'm pretty sure they said they cleaned my apartment up, and I'm able to go back.
And that was one of the reasons we wanted to address the bond.
Yeah, I know. I mean, there's a whole conversation that happened yesterday, so I just want to make sure. So you said somebody has to go they have to clean your apartment up?
They already have done that.
They've done that, and so you're good to go.
I'm good to go back.
Back, if you can get back there.
Right.
And then you're with Avalon.
Right.
And they've got things in place for you.
Right.
Right?
Right.
Okay.
Yeah, I've been homeless for like 7 years. I just got in. So.
No, we talked yesterday. You remember?
Yeah.
Huh? You remember? Because you just waived your fines and costs because you weren't going to be able to get them paid. Just getting yourself on your feet. So, okay. So, what did you want to have done on the case?
Also, we're asking for a 1-week adjournment.
Got it.
We can possibly resolve.
Well, let's do this. Do the people have anything to say regarding bond for this gentleman?
I think you know his situation well.
So what I'm going to do is I'm going to set you out. I'm going to give 2 weeks adjournment. Okay. So I'm going to set you out to September 5th, 2024 at 9, or as your invite indicates. Now you've got a phone. You got a way to get in contact with everybody, right?
Yes. Yes. I have a phone in my pocket.
Pardon?
I have a phone in my pocket.
Okay. And Jones, if I let you out, you gonna mess this up?
I'm not even trying.
I know you're not trying, but you're gonna.
Yeah.
You think you can do it?
Yes.
Okay. So here's what I'm gonna do. I'm gonna reduce your bond. Okay. And I'm gonna grant the motion and give you a personal recognizance bond.
Hey.
Okay. And then with all of the conditions that they gave you before. Okay, so I don't want any drug use or anything like that. And then we'll see you in a couple of weeks. All right. I want you to keep in contact with your attorneys. You hear me?
Yeah.
If you step out of line, what will I do?
Get out of mine.
Okay. All right, Mr. Jones, you take care. Court does recalls case People versus Tyler Meddy.
And Ed Rodriguez for Tyler Meddy.
State your name.
Tyler Meddy.
Okay, you're in court. Don't eat. We've already had to wait for you. Your counsel's been delayed because we've had to wait for you to get back on the screen. Okay, what are we doing on this?
Your Honor, actually, I'm asking for an adjournment today. He is in treatment. I don't have an out date yet for his treatment. I do know that he went in on the August 3rd, and he's waiting for transitional housing. So that's for a 3 to 4 week adjournment to allow him to get out.
Probable cause conference will be adjourned September 19th, 2024, 9 a.m. Bond continue. Thank you.
Thank you.
Thank you.
Appreciate it.
That was the funniest thing about this guy. He had been waiting all morning in court, and he got up to go do something. And about the time he got up, they called his case, and so he had to go sit and wait until the end. And then once he got back on there, it was less than a minute, and he was out of there. So it was somewhat uneventful. Hey, Itzel came out just to say happy birthday to Linus. See, we were waiting before we could end it for her to say happy birthday to Linus, and then we can get out of there for the night. All right. While I'm waiting on her to get her words right, I'm gonna ask real quick. When we do these lives, the comments are hard for me to decide where they need to go. There's a big part of me that wants to put them down here at the bottom, but the people who like their closed captioning, that blocks their closed captioning. So do I make the whole screen smaller? Do I make the court smaller? Or how do we do that? How do we do that to where everyone gets to see the court, but also gets to see the comments and the people that appreciate the closed captioning? How does that work out? So we got a Discord. Send your comments over there, and Jay will sort through them, and we'll figure out the best thing that's going to work out for everybody. Also, if you have any different judge suggestions, I'm pretty boring. I like my judges. I like the ones that I throw up. Like I said before, if it were me, I'd just play Judge Middleton all day. I enjoy that just fine. Lethal friction in the center looks fine. That works. The upper part of the screen is good for comments. Okay, so if we put it right up here, I see where the Omnicast or OmnicastNet upper part of the screen, they fade away anyways. Yep, upper part. Maybe smaller court screen like Biggin does. Yeah, legal fiction. I like that idea. The smaller screen. Whenever I started doing the videos, I was focusing on making it fill all of the screen. And so I'm trying to figure out what's going to make the most sense for it. So maybe tomorrow night I'll try to split the screen. It's just as easy if I were to split the screen, and we'll see how that works out too. So, and Julie, you got a good answer right there. It depends on the courtroom. How about we just get with all the judges and tell them to get in a similar format? Chris, I don't know. Chris Barton saying hadn't seen Judge Bryant in a while. Every time I go over to Judge Bryant's room, she's awfully calm. And we love Judge Bryant, but we love how animated she gets. Sally Port, happy 50th wedding anniversary. That is such an accomplishment. I can't begin to tell you how wonderful of an accomplishment that is. That is amazing. That is truly amazing, Sally. I'm sure you've got some stories to tell. That's amazing, Sally. Thank you so much for sharing that with us. That gives me hope. I've been married for 26 years, and to let me know I got at least another 24 just to catch up. And so we'll start working on that. I'm gonna work on that 24 years to catch up with you. Yep, legal fiction. If you'll take the East Coast judges, I'll take the West Coast judges. I wake up later. But happy anniversary, Sally. Happy birthday, Linus. And legal fiction, happy birthday to you too. I heard it was your birthday. And I think Lethal had said something about Ben. Is there a Ben with a birthday? Yeah, I think Lethal's done went to bed. So well, we're gonna get out of here. Yes, I do, with 6 boys. That is a heck of an accomplishment. Congratulations, Sally. We're gonna go out on a good note like that. Thank you guys, and we'll see y'all tomorrow night at 8 o'clock.